Good afternoon. Good afternoon. My name is Eduardo Peñalver. I'm the Alan R. Tesler Dean here at Cornell Law School. Welcome to the law school if you're not one of ours. If you are, welcome back. Continuing our celebration of reunion this weekend, it's a great pleasure to welcome you to this afternoon's discussion of judicial philosophy and advising U.S. presidents. This afternoon's event features a conversation between two distinguished Cornell Law School alumni who are here for reunion this year. Ari Melbourne, a member of the class of 2009, and Leonard Leo, a member of the class of 1989. Today's event's a reminder of the importance at the law school of our core values of engagement and civility, something that seems increasingly rare in our hyper-partisan and bitter national discourse. Our long-standing tradition of civility and collegiality and our commitment to diversity of belief and viewpoint have served us well during these past few years, and indeed they're what make today's event possible. And I'm delighted to share the news that next year the law school will be helping the university to kick off a new speaker series sponsored by Cornell University alumni Pete and Marilyn Coors. And the goal of the Coors Conversation Series, as we're calling it, is to bring together public figures from divergent points of view to talk about some of the most important and contentious issues of the day. And I'm delighted that Pete and Marilyn are with us here this afternoon. Please join me in thanking them. I think today's event would be right at home in that Coors Conversation Series, and so it's almost like a precursor to next year's events. It's my great pleasure now to introduce today's speakers. Leonard Leo is the Executive Vice President of the Federalist Society, the premier national organization for conservative lawyers and jurists. He's been nicknamed the Trump Whisperer for his role advising the president on judicial nominations. Leonard is a double big red, having received his bachelor's degree from the College of Arts and Sciences in 1987 and enrolling at the law school through our early admissions program. He founded Cornell's Federalist Society chapter here in 1989, and in a profile for The New Yorker, Jeffrey Toobin called Leonard a convener and networker who has met and cultivated almost every important Republican in more than a generation. Business Insider has called him the most powerful recruiter in the world. He's been an influential advisor to 2 U.S. presidents on judicial nominations, and by some accounts is responsible for nearly half the justices on the U.S. Supreme Court. Ari Melbourne is the host of MSNBC's The Beat with Ari Melbourne. He's also chief legal correspondent at MSNBC and a legal analyst for NBC News. When Ari was in law school, he was an editor of the Cornell Journal of Law and Public Policy, and then following law school, he went to New York to work at the law firm of Cahill Gordon, where he worked with fellow Cornellian Floyd Abrams in a practice that specialized in First Amendment law, reporters' privileges, and copyright litigation. After leaving Cahill, Ari went to work as a legal journalist and commentator at MSNBC. He became the network's chief legal correspondent in 2015, and in 2016, Ari won an Emmy Award for his reporting on the Supreme Court. His nightly show, The Beat, premiered in 2017, and it quickly developed a strong reputation and following, both for its sharp legal analysis and for Ari's exceptional hip-hop erudition. The Detroit Free Press called The Beat with Ari Melbourne one of the best shows of 2017, noting that it helped untangle the legal facts regarding Russian election meddling, and also noting that its focus on the facts stood in strong contrast to the partisan posturing of so many shows across the political spectrum on cable news. A recent Daily Beast article praised Ari for his tough but smart and fair-minded questioning of guests from all points of view in different walks of life, whether it be Trump attorney Jay Sekulow or hip-hop artist 50 Cent. In spite of their demanding schedules, both Ari and Leonard have remained actively involved with the law school, including by coming back to Ithaca to speak with our students on several occasions, and I'm delighted that they can both be with us here this afternoon. Please join me in welcoming back to Cornell Law School, Leonard Leo and Ari Melbourne.
Thanks to Dean Peñalver for such a nice introduction. It's a thrill, I think I can say it for both of us, to be back. And what a nice room of lawyers, which means there'll be many opinions and far more expertise out in front of us than on the stage. So I'm sure everything that we get slightly wrong, we'll hear about, if not now, then by 6 p.m. dinner. So we will keep that in mind and be as intellectually humble as we can. Leonard is such a fascinating person for us to hear from today. And although there is debate about his work, some might even say controversy, there's no debate about the enormous commitment he has to his work and his issues, as well as his influence. There's really no debate about the influence, which I'm sure he will be gracious about because I've spoken to him before. But the fact is that he's been involved in the selection or confirmation of the majority of the members of the current Supreme Court, which is really something, and I think something interesting for Cornell Law. So the first question I put to you is, how did you get this job? Is this a job? Did you create this job? Walk us through it from leaving law school to what you do now.
Well, first of all, it's great to be here with you. I think you're a great journalist and commentator. It's great that you bear the Cornell alumnus moniker. And it's great to be here with all of you and at the law school. Under the dean's leadership, this place has really become a great institution for academic freedom and intellectual diversity. And it's so exciting to be here and to see that happening at our law school. I guess it's a job. I mean, I leave home, I work, I come back. It's a job. But it really all started, Ari, I think here, in a way. I had gotten to know a little bit about the Federalist Society when I was actually in Washington as an undergraduate Cornellian, because there's this thing called the Cornell in Washington program. And I'd gotten introduced to the Federalist Society a little bit down there and decided that when I came to Cornell Law School, if it didn't have a Federalist Society presence, I was going to try to set up a chapter. And so I started that here with a group of other students. And then I started learning a lot about the role of the court, and in my view, really, the importance of enforcing and respecting the structural constitution if you really believe in the preservation of human dignity. If you really want to preserve the dignity and worth of every person, you got to have enforceable limitations on government power, stuff like separation of powers and federalism and so forth. And that's really what got me into the whole business of being interested in the role of the courts. The idea that the courts had a duty to respect and enforce those structural limits on government power, and that in turn would hopefully protect the dignity and worth of people. And so that's really where it all started. And then while I intended on practicing law at some point and did briefly, I ended up at the Federalist Society long term and really have spent most of my years there really just building a pipeline or infrastructure of talent to help to build out the legal culture in our country.
And so let's take that to, and is my mic okay, or is it really loud? I feel like mine's more loud than Leonard, and so in hip-hop, sometimes they say, you know, put it up, put it down. Let's match our mics if we can. I don't want to be booming over you like an Emperor Darth Vader situation. I want some equal volume.
I'm used to that. You know, it's not a big deal.
So you basically fashioned this role, and nominees of the Republican Party and presidents of the Republican Party come to you, and we're going to get into that dialogue. Let's start with now, and then we'll go back, because we're living during interesting times, to say the least. And a television star and real estate entrepreneur and branding businessman gets the Republican nomination. And people don't know whether he's going to win. The judicial nomination issues are paramount. And not only does he also come to you, which we'd like to hear about, but he does something that is almost never done, which is he ends up releasing a list of names of the people that he would consider for the court, partly to deal with skepticism about him being such a newcomer, at least to Republican politics. Tell us anything you can about how that all came about.
Wow. Well, it all starts on the day of Justice Scalia's death, actually. As some of you may remember, that was also the night of the first Republican primary debate. And so at some point in the very late afternoon, we get a phone call from Don McGahn, who is general counsel to the Trump campaign. And he says, look, you know, this is going to come up in the debate, and, you know, Trump wants to mention a couple of names of people who would be the types of folks he would nominate to the court. And we were really fascinated by that and floored by it because that had never happened, right? In all the prior presidential debates, the furthest a Republican candidate ever gone was what George W. Bush said, which was, I'm going to appoint people in the mold of Clarence Thomas and Antonin Scalia, right? But they were already on the court. So this was different, and this was just downright edgy, right? So we talked a bit, and basically, I think collectively everybody had settled on mentioning Bill Pryor and Dianne Sykes, two judges, one from the 11th Circuit and one from the 7th Circuit. Trump does that during the debate. He gets that on the trail a bit, and he starts to realize that, you know, this is a really big and important issue. I mean, he had vaguely heard that, you know, one of the president's most lasting legacies is, you know, the appointment of judges. But, you know, this was in a lot of ways larger than life because here he was faced with, you know, a vacancy on the Supreme Court right in the midst of a presidential election campaign. So really what happens is it's March now of 16, I believe, and I'm invited to come to a lunch in Washington with a group of other people. Jeff Sessions was there, Senator Tom Cotton, some other leaders of the conservative movement. And it's after that lunch where we have our first serious conversation about judicial selection and about the Supreme Court. And it was, Ari, it was an absolutely fascinating conversation because he had all these questions that he asked.
Was this in person or over the phone?
No, in person. So we left the lunch, we went to a separate room. It was Donald Trump, the candidate, Don McGahn, his general counsel, and myself. And, you know, he asked a wide range of questions. Interestingly, he wanted to know why conservatives were so upset with David Souter, which dated him a little bit, but that was the sort of the first question. He asked a whole series of questions about why the movement was so fascinated with Justice Scalia throughout his life. He asked some questions about the Obamacare case and Chief Justice Roberts. And then at some point he sprung this idea about the list, right? Hey, I've got an idea. What's that? Well, I want to put out a list of all the people, from which I would pick a Supreme Court justice. And my immediate reaction to that, being a lawyer, was to say, well, that's never been done before. And so he said, well, is that a reason for not doing it? And I said, well, no, why do you want to do it? And he said, well, nobody knows who I am on this issue. And this is a way of explaining to people what it is I would do in a very clear way. You know, we talked about it a bit, and I had gotten a little bit of a tip-off that this was his idea, so I happened to have a list in my pocket. And at one point he said, so what kinds of people would you put on that list? I said, well, I happen to have would you like to see it? Yeah, I'd love to see it. So we talked it through a bit. But at the end of that meeting, he had not yet decided to absolutely commit himself to picking from the list. Really wasn't until later that happened, when the second list came out. At that point, he said he was committed to picking from the total group.
So at that meeting, you handed him a list of how many names?
At that meeting, it was a list, well, it was a list of 8. And he said, well, I really wanted a dozen. And
because judicial nominees are like eggs. So you always want a dozen if you can get it.
That's right. So I said, well, I don't know. We'll have to think about that, but here's 8, and we'll get back to you.
And I'm going to ask you this question. I don't know whether you want to answer it or not, but your list comes out of a careful process based on each potential nominee. His list sounds like it was seeking a certain number. Is it fair to say that you had it seemed like you had different goals for what the purpose of the list was?
No, that wouldn't be the case. So we had conversations about what it was he was looking for. And there were 3 things that he stressed. One was what we would call a brand, okay, what he would understand as brand, which is I want someone, and this is his language, extraordinarily well qualified. Now, every president wants that, but you know, Donald Trump being a businessman, right, he understands branding, and so he wants people with the real great pedigree.
And we're going to get to your other two, but just on that point, that's interesting. What did that tell you about his view of this potential presidential obligation? Because I say this not as a criticism, but an observation. In other areas of government, he has been less concerned with traditional credentials and experience. He certainly has hired out of TV green rooms, which we don't mind. I mean, I'm always up for a backup job if you want to hire the people off television.
You got a law degree. There's a possibility. You never know.
But he has done that in other areas of government. Yeah. I think it is fair to observe. And yet here you're telling us he was not going to go that route. He was not going to put Judge Judy on the Supreme Court.
Yeah, and so for me, this was really important. And it hearkened me back to something that Justice Scalia once told me, which was, you know, you have got to be really smart. Because if you're not, you're going to get snookered into doing things that are the wrong thing. And so you got to be able to assess those arguments independently with your own force of judgment. And so for me, that was like, whew, this is good, okay? But then when he hit the second one, that's when I was really excited. Because there he said, I want people who are, quote, not weak. Now, I knew what that meant, okay? We don't want people who hide in the tall grass, okay? So we want people who are going to do what they know is right and are going to be strong and principled, and they are not going to look behind their backs to see how they're getting criticized. And to see a possible president understand the importance of that nature of one's character told me that this could potentially be a really value-added process during this administration. And the third one is what you would expect. I want people who are going to interpret the Constitution the way the framers meant it to be. And I thought that was an elegant way to put it. I don't know whether he came up with that or someone else did, but those really were his guidelines. And that's pretty much what he's stuck to.
So that list of 8 then grows?
Grows to 11. We couldn't get to 12. I always remember the one phone call where McGahn calls and he gets the list and he says, there's only 11. And I said, yep, there's only 11. And he said, well, he really wants 12. And I said, well, then you guys can make it up. Put a 12th one on there, but that's the best we can come up with. And then ultimately we get to the full list after that, the 20. Of course, we add, the president adds Mike Lee from Utah, Senator Mike Lee. As well, which was a little different from the others who were all judges, sitting judges.
Did any of those individuals get a heads up, and does it affect their work if they're on the bench to be on a list like that?
None of them got a heads up. In fact,
which is wild.
Yeah, it is wild. One of them, Don Willett, who at the time was a sitting justice on the Texas Supreme Court, was at a book signing event for Governor Greg Abbott, and we call him the tweeting justice because he tweets a lot, and his Twitter account started blowing up, right? Because everyone was like, oh my gosh, you're on this list. And he's sitting there like, what list? What is this? So finally he goes out of the room and he finds out that this list came out and he was on it. So nobody knew. And it was really important that they didn't know. We wanted all of them to be as distanced from all of this as possible and be able to just say, I don't know what this is about. So nobody knew.
And then the president puts out the list. He gets feedback. And your view of that compared to the way it's been done in the past, and do you think this will become a new precedent? Do you think this is something that even people in the other party might start to do?
First of all, I thought this was an absolutely brilliant stroke on his part. I mean, from the conservative movement standpoint, you have to understand, most people didn't know who Donald Trump was. And certainly, you know, he had never talked about the courts and the judiciary. He hadn't had a public life in that way. So it was brilliant to come out with something which not only said, well, this is sort of kind of what I'm going to do. No, this is what I am going to do. I'm going to pick from this list. And of course, that was a risky proposition for him, but it was, I thought, a really important part of his strategy. And then, of course, you know, he he makes this, in a lot of ways, a defining issue during the election. The exit polling showed that 22% of Americans who voted identified the Supreme Court selection issue as the most important issue in the ballot box. So I think it was 61% of Republicans. So he had a real understanding of the importance of this issue to the American people.
What does it tell you about Donald Trump that he gathered enough information to seize on an issue that you're saying by his own admission was not his specialty, or something that he thought he had a strong brand, to use that word, at the outset?
You know, it's a combination, Ari, I think, of both pragmatism and a commitment to some broader idea. So the pragmatism is, look, he's running to be president of the United States. He's going to represent the country. People around the country are telling him they care about this, and so he absorbs that issue. And I think that's perfectly fair and legitimate for a political leader. The second is, I think, brought out of principle. You know, if you look at the first couple of paragraphs of his inaugural speech, he gets into the issue of self-government. I think he invokes Lincoln and some others, and occasionally you saw a little bit of an understanding that there's a real inextricable link between what the court does and how far it goes in its work and the preservation of self-government. Especially saw that when he talked about the Obamacare opinion in that very first post-lunch meeting, where he was very critical of the Obamacare decision. And I remember saying to him, well, I mean, I have my own opinion, but I asked him, well, why do you think it was wrong? Because he had said it was wrong. And so I asked him, well, why do you think it's wrong? And he said, well, because John Roberts just made it up. And that's just not, this tax thing, he just made it up. And he said, that's just not what a judge ought to be doing. And, you know, there were a lot of people who were learned in the law and were lawyers who were saying that. And I think it was valuable to see how he was thinking about these things.
Which brings me to one more Trump political question, and then I want to ask you about some of your other work. And this is a little more political than legal, if you'll excuse me, but perhaps it will be interesting given the way you've worked with him. The president has a reputation, and I think his supporters really like this. I think his critics resent it, but he has a reputation for rolling over all kinds of people, including people who have or claim to have government expertise, scientific expertise, and otherwise. You are interesting not only to us here as lawyers, but also just more broadly, politically. You are a person who, not only by your own telling, which we believe you, but through third-party validation and the picks on the court, has had influence over him from your place of expertise. And so I wonder, do you have a view of how it is that this untraditional candidate who was so underestimated and now has become president, from working with him, how he decides when to actually listen and react and defer, because I think it's fair to say he would defer, as you just put it, to some of the legal leadership here, and when he does not. And for political examples, when I was covering him in the primary and I was going to some of his rallies, I thought it was fascinating. He didn't take any of the Republican orthodoxy positions as gospel. So whether that was the Iraq War, or views on trade, or how most Republican candidates running for office would talk about Wall Street, he threw it all out the window, seemed to start from scratch, and then if he hit a red line, guns, abortion, the courts would be ones I noticed, then he would pull back. Oh, wait, the people at this rally actually care about that, but they don't care at all about the way that Washington Republicans, or many of them, were talking about trade, so I'm going to continue to throw trade out the window. Did you glean anything or learn anything about how he does that process? And I wonder, do you think he's still underestimated at that skill set?
I've thought about how this all happened and why, in a way, the judicial selection project, if you will, does in a lot of ways look and feel different than other things in Washington right now. For the life of me, I really can't figure it out. I think it was probably a combination of factors. There's no question in my mind that Justice Scalia's death, really crystallized this area for him. And it was very interesting because in the first couple of conversations, he asked a lot of questions. So one, this is someone who's obviously a little inquisitive, okay, because he's asking questions. He's not just mouthing off, right? He wants to know things. Came to a point, actually, where he was asking enough questions about Justice Scalia and his background and his personality, his demeanor, the way he did his job, that we just gave him Maureen Scalia's phone number and told him to call her. And he talked to her 2 or 3 times about him. He asked a lot of questions about Clarence Thomas and why does everybody like Clarence Thomas so much, right? And so there was some conversations about, why does...
I think some people in the room are saying, define everybody. But he means...
That was a quote.
But I suspect that the president means everybody who is in his base.
He, quite often people, when he would mention Justice Thomas at his rallies or so forth, there would be the largest applause that you would see during that rally. And you'd say, why does that happen? And the reason was, as we explained to him, was because this is a man who has basically said what he believes. And he's not been afraid to do what he wants to do, say what he believes, say what the Constitution in his view means. And that funneled into this whole issue of, what do you want in a justice? Do you want someone who's independent, and who's going to basically call him as he sees him? So I think some of those were things that funneled into his thought process. Other areas, you didn't have that same sort of gestational period during the campaign, right? I mean, this was a big, everybody's got to remember, this was a big, remember how big of an issue this was? This was a big issue in 16, right? You had a lot of media attention on this. This came up in every presidential primary debate. When people would talk about it at rallies and constantly on the news. You had the whole Merrick Garland controversy. So he had time to think about this.
Well, and politically, I'm not making a legal comment, but politically, Merrick Garland was not as well-known or I think as politically popular among likely Democratic voters as some of the names and the Thomas references were on the right. So you had the Democratic nominee running on a grievance about a lack of process, which I think is always politically hard to run on, and not what you might call, or some, I won't put words in your mouth, what some would call a more movement conservative figure.
Yeah, no, I mean, what at the end of the day, what candidate Trump channeled was the conservative movement's understanding of the idea that you needed to have a court to revive what I call the structural constitution, but what people basically understand are, those limits on government power contained in the Constitution. And that was a principle that went all the way back to Ronald Reagan. This is where it all started, right? Judicial selection in the conservative Republican space became more philosophical and ideological under Reagan. At the end of the day, when you look at all of this stuff that's going on now, this isn't something that just popped up 2 years ago. This isn't just Donald Trump, okay? This is Ronald Reagan. This is Ed Meese. This is many, many decades of a philosophically based, ideas-based movement that thought, whether people agree or disagree, that thought very carefully about what they felt the constitutional order was supposed to look like, and began to build both a set of operating principles and an infrastructure to try to achieve that. And this is the culmination of that in Donald Trump, who some might say is sort of an unlikely standard bearer for this, but this is where we are in our movement. And
is there a comparable counterpoint to Federalist Society and Leonard Leo on the left right now?
I don't know. I think the law schools are, and they're pretty important. The law schools are really the institutions right now that are, churning out, mostly a center-left or left-leaning legal culture. The scholars in those law schools are probably driving a lot of the conversation and debate on the left about these things. I noticed a New York Times story this morning about a group that some prominent members of the left are forming to begin to think about who their prospects would be for the courts in a Democrat administration starting in 20.
So let's go through some of the other confirmations that you were involved with.
Sure.
Why don't we start, as mentioned, with Thomas?
So I had just been coming off my clerkship, actually, on the D.C. Circuit, and I was supposed to go report for work at the Federalist Society, and I had gotten to know then Judge Thomas clerking on the D.C. Circuit, and decided that I wanted to take a few weeks to help him with his confirmation. So that was really my first experience with it, and of course was thrown right into it with the second phase of that confirmation, which was the the Anita Hill controversy. And so, that was really my first experience with the confirmation process, and of course what had become very apparent, not only during that phase, but the earlier phase of the confirmation, that the Bork confirmation process had really, in a lot of ways, poisoned the well, become a much more hotly contested, politically driven process. And so that was a pretty brutal experience. Different, right, in the sense that that was early on in these battles, so there wasn't really an extremely well-mobilized conservative movement back then. It was a pretty ragtag group of conservatives who were, involved in the confirmation process. In contrast, the liberal movement was very well established in this area. They had come off the Bork confirmation and some of the confirmations between 1985 and 1987. They understood how to fight these battles and were very potent and very formidable. So it was a very, very tough confirmation process. At the end of the day, it was Clarence Thomas himself who secured his confirmation and no one else. He took it upon himself to wage his own defense. He cut himself off from the White House and made his own decisions about how to defend his reputation and his character in that final phase. And it was really driven very much by him.
When then you look at Alito and Roberts, you're playing the role of advisor.
Yeah, so that was George W. Bush. So there were really four people who were most active on the outside back then. One of them you mentioned already, Jay Sekulow. He kind of was, if you will, sort of the representative of sort of the religious bloc of the conservative movement. There was Ed Meese, who of course was an icon in the conservative movement and who came from the Reagan experiences with judges. Boyden Gray, who had been George H.W. Bush's White House counsel and had been, helped to secure the confirmation of Clarence Thomas, and then I was the fourth wheel there. So we had sort of helped to build out a movement on the outside, and this was really the first time where we had a well-funded, well-organized outside movement to support the confirmation of judges. And then, of course, you had, the president. And one thing I should really say is, at the end of the day, the president is the guy who has the decision rights. I mean, no matter what you say about outside groups, senators, advocates, surrogates, White House counsel offices, justice departments, the buck stops with the President of the United States. And that's where, at the end of the day, the decision really gets made. He gets all the credit. Sometimes he gets all the blame, but he gets all the credit for, achieving whatever his agenda might be, Democrats or Republicans.
So, but take us inside the room, say, with the president deciding on how to fill the vacancy of the
George W. Bush?
Say the Chief Justice, yeah.
Well, it was a different style in the George W. Bush administration. Honestly, it was in a way more compartmentalized. I'm not sure George W. Bush thought as much about judges except when there was an action-forcing event where he needed to, right? Now, maybe some of that was the war, right? But you know, whatever it was, he was really focused then, but I'm not sure really talked about it, thought about it very much in between. Donald Trump's been a little different. You know, you'll see him, and he'll say, how many more judges do we got to confirm? You know, what are the stats? How many have we gotten so far? Are we going to get another one? You know, he really is engaged about this issue in a way that's a little bit striking. Some of the process is the same. So George W. Bush interviewed, gosh, I think about a half a dozen, maybe he interviewed about a half a dozen candidates for the Roberts and Alito seats. And President Trump has done private interviews as well. So, and they've more or less lasted about 40 minutes or so, both presidents. So that level of engagement is the same, but you do see a slightly different interest level. And the other thing is that the process is a little bit more fluid with President Trump. So you know, he talks to a lot of people. A lot of people talk to him. I'll tell you one funny story. We're at a Christmas party just shortly after the election. Mm-hmm. And everybody's having fun, good time, so on and so forth. He's on his way out of the party, and he sees me from across the room. We make eye contact, and he beelines up, and my wife Sally is with us, and I figure, oh, you know, she's never met him before, a great opportunity to meet him. So we introduce him, and he's like, hi, how are you? Now, I got this question for you. There's this judge out in the Midwest named so-and-so, and I'm told by, I'll name nameless, this very prominent person that, you know, he's a really, really good judge. Why isn't he on the list? And you know, we had a conversation, but after that conversation, I just said to myself, my goodness, I mean, we're at a Christmas party. The conversation he had with this person was approximately 2 to 3 weeks ago. He remembered the person's name. He remembered the person's name who recommended him. And I just couldn't believe that outside the context of a scheduled meeting where the staff secretary of the president gives you the briefing book for the meeting, you would be as interested and engaged on it. And so
which
very
is different
than any other president.
And not only different than the other presidents, it's also different than his Twitter persona.
Oh, yeah, yes. I mean, you know, the whole Twitter thing is totally different from the experience that those of us involved in the process have gotten over the course of the past couple of years.
So what did Bush like about John Roberts? How did he finalize that decision, and how did that confirmation go? And who came up with the umpire talking point, if you know?
Yeah, well, the umpire talking point was John Roberts.
Yeah.
I mean, that was Roberts. And you know, that's not unusual. Usually the top line you see, right, is normally the nominees. It kind of has to be, because if you're going to repeat it 14, 15, 50, 16 times in the confirmation hearing, it better be something you made up and you're really comfortable with, otherwise it's going to start to look really bad. So that was Roberts. In terms of why the president liked Roberts, well, I think it was a combination of things. I mean, first of all, I think pedigree. You know, he had exactly the kinds of credentialing you would expect from a Supreme Court prospect, and secondly, you know, he had somewhat of a record. It was a smaller record than some of the people we're seeing now, but he had somewhat of a record of being demonstrably committed to textualism, originalism, more limited role for the judiciary. It was harder back then, right? Because, you know, a lot of these judges who were serving back then, I mean, Roberts, I think, only had, Ari, 38 opinions. So you only had 38 opinions really to look at. I mean, Brett Kavanaugh had 300 and some, and Neil Gorsuch had 768. So, you know, slightly different, you know, cache of stuff to look at. But that was what really drove it. And Roberts had, you know, he was kind of out of central casting, right? You know, he looked the part, he spoke the part. It was clear the president was going to like him a lot. And personality is really important, right? I mean, those conversations that a president has with the prospective nominee, those are proxies for what you see in a person: character, right? Integrity, strength, independence, humility, honesty. And presidents, every president, you know, Donald Trump, George W. Bush, I'm sure President Obama, they all look for that because they know how important these jobs are.
Is it a conscious process to focus on the difference of filling the Chief Justice position? Roberts clearly is someone who takes that mantle and is concerned about the institution of the court in a different way than potentially some other members. And as you know, there's scholarship suggesting that even his votes have shifted with the idea of defending things beyond just where he might have personally been in past decisions.
Well, I mean, Ari, you remember that originally he was nominated to be an associate justice to the court, right? And then we switched. So Alito became. So what happened was O'Connor, right, goes, and then Rehnquist goes. Now I think the original intent was that Roberts was going to be an associate justice, but then as things moved on, it became apparent that.
And then who would have been the chief spot?
Well, and then the president really felt that Roberts had the sort of overall look and feel of a chief justice.
Because it's hard to imagine Alito being the type of Chief Justice Roberts is, although I guess one could guess.
No, I mean, I think part of what President Bush saw in John Roberts was that ability to preside over the court. Remember, you had come off of a Chief Justiceship in Bill Rehnquist, where, you know, Chief Justice Rehnquist was enormously well respected by the entire court, liberal as well as conservative and moderate blocks of the court. When Chief Justice Rehnquist wanted something done a certain way, we're not talking ideology or votes in cases, but the cadence of the court, getting the work done, talking through how opinions were going to be issued, keeping things running efficiently and civilly, right? Chief Justice Rehnquist, you know, ran that court with an iron hand. He was enormously respected and admired by everybody on that court. So there was a lot of pressure to put someone in the chief's seat who had the gravitas, right, to continue to maintain that kind of collegiality, efficiency, smooth ordering on the court. And I think there was a sense that John Roberts had the demeanor and the ability to do that.
What have you learned about the justices themselves from going through the process? You said they picked their top line points in confirmation. We've seen different bruising confirmation battles. We read reports about how decisions are made on the court, although it remains by far the most opaque institution in the federal government in terms of knowing beyond what's written, what's really going on. Can you share with us anything you've learned about the way the justices are? Do they think back on their confirmations? Does that impact ever the way that they rule? Do they care about their public profiles more than they let on? Anything you've learned?
The first thing I would say, and I would say this across the board, about 3 weeks into every confirmation process, the Supreme Court nominee comes to the realization that his confirmation is going to stand or fall on him. Okay? You can have all the handlers in the world. You can have lots of people prepping you for meetings and lots of moot courts, but at the end of the day, it's going to stand and fall on you. You're going to have to make the really big decisions about how far you want to go in describing precedents, how far you want to go in describing your own philosophy or views about things, If a real crisis comes up, like we've seen in some of these confirmations, how strongly you're going to come out in defense of who you are. So one of the first things I notice is about 3 weeks in, the nominee gets really serious. And really, in a lot of ways, for large parts of the day, isolates himself and prepares on his own. I always remember Neil Gorsuch. He spent 10, 11, 12 hours a day in this office, in the old executive office building off the main White House, by himself, reading all his opinions, reading all the major opinions of the court, just holding himself up and sitting there and reading. And, it was very interesting in some of the meetings where, Justice Department officials would say, here's how you should talk about, the Griswold line of cases, right? Right? He would sit and listen, and it's okay. Well, I'll think about that. But then at the end of the day, he, and this is the case with every nominee, basically comes up with the tone and style they're comfortable with. So first of all, I think that's important, because what it shows in each of these people is this sort of sense of independence and personal responsibility for who they're going to be. From nominee to nominee, Neil Gorsuch, very much a Westerner. I mean, Coloradoan, that sort of gosh senator sort of thing that you saw. It's real. I mean, that's him. The other nominees, I guess there's nothing that comes to mind in particular, but in Neil Gorsuch's case, I remember it was different. There was a little more of a Western quality to him, which was kind of interesting.
We'll turn the page to, we got to get into it, right? We wouldn't not get into it. Brett Kavanaugh, a justice and a confirmation battle that was as searing as anything probably since Bork, if not more so. Very strongly held views. Walk us through what you learned as you learned it, what you thought, and what are we to take from it?
Well, I think to the extent anyone had any glimmer of hope that the confirmation process was going to become less political, less embattled, I think the answer is that's probably not happening anytime in my professional life. The lines are drawn pretty sharply. The tools that are used to support and oppose nominees are well sharpened and will be used now and in the future. Part of this is institutional. The court has become such an important part of American life, makes so many consequential decisions, that it is only natural that the Senate would view it through a very political lens. And so this is kind of the process that we are, I think, unfortunately left with. Sometimes the battle lines will be drawn over ideology, and really when you look at it, that was Robert Bork. There was very little of the personal background issues in Bork's case. There were one or two small things, but really that was really strictly a battle over philosophy and ideology. Thomas and Kavanaugh were a combination of both. You have to think about the confirmation process as two phases in both of those instances. Phase one was the ideology philosophy phase for the most part, where you just had a battle over what he thought and whether that was the right way to think about the Constitution and how that affects the dignity and worth of people in our country, right? The second phase is where, it became sort of more an issue of how can this person be maligned or destroyed politically. Phase two, at the end of the day, will take on the character of the nominee. The nominee will have to decide how much he wants to fight and defend himself. And in both cases, it was not, I think, obvious at the outset how both Clarence Thomas and Brett Kavanaugh were going to decide to proceed. In Clarence Thomas's case, there were a couple of days there where he really had to reflect carefully about what he wanted to do, what he wanted to say. He talked to his very close friend, John Ashcroft. Not John Ashcroft, I'm sorry, Jack Danforth, Senator Jack Danforth. Prayed a lot and then made the decision to basically go on the offensive. And that was much the same with Brett Kavanaugh. He kept his counsel very close to his vest. He made his own decisions about how he was going to proceed. Did not show the White House his statement. He wrote that on his own and didn't present it to them. And so that's how the process unfolded in both instances. How does this affect them afterward? Well, that's one of the reasons, really, a president really should look for someone who has the strength of character to just soldier on, right? I mean, you want someone who, no matter what happens in the confirmation process, is just going to do the right thing when they're on the bench, and isn't going to look back and say, well, what do people expect me to do, right? Or were people trying to chasten me and make me be something less than I want to be? You can't look back. You have to just be a strong person and, do what you think is right when you're on the bench. And if you look at Clarence Thomas's first two terms, there's no question that, he made that decision. I mean, if you look at, Holder v. Hall, Hudson versus McMillan, a couple of the cases where he actually flipped his vote. He originally, voted with Rehnquist and the majority, and then ended up dissenting. I mean, I think Jacobson was one of them, involving I think it was an obscenity or pornography type case. He really charted his own course the first couple of terms and really just did his own thing. Now, we haven't, I think Neil Gorsuch, much the same. He's clearly staking out ground in certain key areas that he cares about, the administrative state being the big one, which came up in his confirmation hearing. Brett Kavanaugh, it's a little early. I mean, a lot of the big cases aren't out yet, but I think we'll get some glimpse into, how, vocal he wants to be at the end of this first term.
And do you think, as you described your view of the confirmation process, do you think the issues there are that those allegations, if true, were still not disqualifying? Or you think that the process has shifted where judges who are confirmed or have been vetted for lower courts only find these issues raised when they're headed for the higher court?
You mean are these issues going to come up? Well,
in Kavanaugh's case, for example.
Well, I mean, in Kavanaugh's case, he had been through, what was it, six FBI background investigations prior to his background investigation for the Supreme Court. He did not.
Well, we are definitely going to do questions, but I'm going to.
So
wait for them.
Yeah, he had been, yeah.
But I'm glad people are listening.
Gee, it's getting awfully late. I
mean, let me put it a different way for you.
Yeah, because
There's the view that if something comes up for a job promotion of this magnitude, certain allegations, if proven through whatever standard of proof is used, may be disqualifying for a promotion, even though you still maintain the very important job that you have. And then there's the view, I think, that many of Kavanaugh's defenders and others have raised at these times, which is similar to what people say during the heat of political campaigns, which is that sometimes it seems that things, whether or not they're true, are being surfaced strictly for political reasons. And so as you looked at
my view of what happened?
Your view of what happened and whether, if true, this was disqualifying for the promotion.
I don't know. I don't know why the issue arose. I can't get into, I'm not going to judge the people who made the allegation. All I can tell you is the issue was put into play, and it was incumbent upon the nominee to explain himself and to defend himself, and it was incumbent upon those who were making the allegation to put their best case forward. I hope that the people who raised this allegation and people who raised allegations in other confirmation contexts, not just judicial ones, are doing it because they truly believe that those were the state of affairs. And I truly hope the people around them are defending that person who made those allegations for the right reasons, which are not basically to play a game of political spoils. So, but I'm not going to judge who the intentions or integrity of the people who made the allegations. And look, in the fog of war, right, when you're in this stuff, as I was and others were, we don't think about that. I mean, you don't have time. All you can do is...
Well, you're fighting to defend someone that you're advancing their confirmation in the role you play, unless, presumably, something that was raised that was, in your view, so problematic that might change your position. Well, that could happen.
Yeah, I would clarify that in one way, though. We're not just fighting to defend. We're fighting to figure out the truth. I mean, there is a point. This was the case during the Thomas confirmation as well as the Kavanaugh confirmation. When an allegation is made, you take it seriously, and you have to ask certain questions. You have to obtain certain information. You have to make certain decisions. You have to put the nominee on the spot, and you have to make sure that everyone is comfortable with where things stand. So yes, there comes a point where you say, okay, it's time to defend. But there is that interregnum period, that morning the Post story came out, that Sunday morning, between then and a couple of days later, where there's a lot of explaining to do, and there's a lot of analysis that has to be done. And you want to get to the truth, and you want to understand what's going on.
I want to ask you about one more broad topic, and then turn, as promised, 2 questions. We're living in a time where a lot of America has been going through law school, if they've been watching the news, and following these investigations, and following the Mueller probe, and then being told there was a report, and then the report comes out, mostly redacted, but most of it out, and then Mueller finally speaks and says, please read the report. And it's been out, and people decide whether to read it or not. And the president says, you don't need to read the report, just read my tweets. No collusion, no obstruction, you're done, I saved you time. And the country has to, in a civil democracy, has to decide how to process all the available information and move forward. I say all that in the context of the media environment we're in, with a very persuasive, very omnipresent president. As a framework for how you feel about the Supreme Court, which is much more in the Mueller report camp. Read our opinions or don't. What we say matters. Our rulings matter, and that's it. They haven't relented on cameras in the courtroom. They don't do press conferences. They certainly don't tweet. Every so often they'll write careful books. You've been up close to this, and you have a sense of the people there and how they've obviously evolved. The court is different and more diverse in certain ways than it used to be. But do you think that this type of court, with this much reticence for engaging in the way we live now and the way we communicate now, A, do you think it'll stand? And B, to the extent you're willing to weigh in, do you think it's a good thing? Or do you think eventually, as FDR went to the radio and JFK went to television and this president goes to Twitter, that eventually these things have to adjust if they're going to maintain a position in public life where they will be understood in the broad sense of the way people live.
That's tough, right? Because on the one hand, we have a court that is more outsized and more influential in American public life than the court had been through a good chunk of its history. So it's tough, right, in a democracy to sort of see that. I go back to the fact that judges wear black robes, and there's a reason they wear black robes. They wear them because it's supposed to symbolize the idea of anonymity, the idea that this is not about who I am, it's not about me as an individual. I don't have a personality, right? I'm just supposed to be interpreting the law as it's written. Now, of course, we're humans and frail by our nature, so we don't always succeed at that. And
I would only gently push back for your analysis that two of the most known and popular recent justices, Scalia and Ginsburg, are known to their followers a little bit by their personality.
They're known by their personality, but when they speak publicly, most of the time, they have spoken about the business of judging and jurisprudence and about the role of the court in our constitutional system. I would be very concerned if we got into a world where justices started going beyond their opinions to explain what they did. So you issue your opinion, and then you have an interview with Ari, and you say, well, look, I mean, I did this because, I had this colleague who wanted to go further, and I really felt that it would not have been a good idea to go further, so I established a compromise position.
And as for the medium, so let's say we stick to that, but the idea that they allow audio and not video, they feel strongly about that. It's certainly a stylistic distinction, right? We wouldn't claim it's a substantive distinction because the material of the oral argument is available, just not in the way that most people consume stuff now.
Yeah, this is the cameras at the courtroom issue, and I have to be honest. I don't know how I feel about that.
You don't have a position?
No, I've gone back and forth on it. I know that the primary argument that people have made has been, well, if you allow cameras in the courtroom, it will cause lawyers to grandstand, and
which has never happened before. So obviously that would be a new thing.
And it becomes a little more theater and a little less conversation between the justices. I don't know.
Yeah.
Since I'm actually not a Supreme Court advocate and I don't argue before the court, it's actually hard for me to figure that out. I do see in the court something very important. And really good Supreme Court advocates are great at this, right? Guys like, Seth Waxman and Paul Clement and so forth, right? They have these, it's not Q&A, right? It's this conversation that takes place. It's a wonder, I don't know how many of you have been to Supreme Court arguments, but you get to a good argument and it's very conversational. And I would not want that to be lost, because that's really where a lot of the valuable information comes out. A couple of justices have told me that the value of that conversation is, you've read the brief, but you don't always know what it is the lawyer really wants to put an accent on.
Mm-hmm.
You really want to know what's driving the lawyer's perspective on the case, or the client's perspective, right? And it's in that conversation where that begins to become apparent. Now, if you could have cameras, right, in the courtroom, and you could preserve that environment, I'd be fine with it. That would be the question for me, and I don't know the answer.
Answering a question with a question. It's very Socratic. What we want to do now, because we have, as I mentioned, such knowledge and wisdom in the room, is engage with it a little bit. My proposal would be to do 2 questions at a time, and to identify your name and class or affiliation, if you're willing. And comments are fine too. I would just say if we keep questions or comments under 60 seconds, if all you want to do is tell Leonard why he's wrong, you can do that. And I'll pair it with a question. So we'll do 2 at a time.
That happens a lot. I'm used to it.
I see a professor. We can do the mic.
Not just a retired professor, he was my con law professor. I apparently didn't learn very much from your class, but...
I have an observation and a question. The observation is that the Federalist Society is not, as you know, homogeneous and has gained much of its influence by having conservatives of all stripes in it, and doesn't make recommendations as to judges. So I assume that in advising presidents, you have not had your Federalist cap on, but it's been a separate consulting gig. The question I have is whether there have been judges in the lower courts that you have not recommended, that the president has recommended, and particularly those who don't meet the ABA standards, or whether there's a gulf between your views, which I doubt, and the ABA standards.
Great, and we'll take
And if so, how do you account, what kind of factors led to those recommendations?
Oh, the short list.
And we'll take one more. Yes, sir.
My name is Dan Harmon. Do you believe that Donald Trump's choices of judges are to satisfy his own core beliefs or to satisfy his base? And I ask this in view of the fact that his belief in pro-choice was his opinion prior to being president. So is he picking judges just to satisfy his base, or does he have any core beliefs in this?
Okay, so...
And does he have a soul? As the professor would say, they're just questions.
They're just questions.
They're just questions.
Does he have a soul? So first, Professor, on your questions. First, no, I don't represent the Federalist Society when I engage in that work. And in fact, I've taken leaves of absence from the Federalist Society during Supreme Court confirmations precisely because those become so visible and so political that I just can't, and so time-consuming, frankly, that I can't see myself doing both of those things and maintaining the tone and style of the institution. It's a little hard when people on the outside just say, oh, this is the Federalist Society's list. First of all, it's the president's list, okay? He owns it, okay? But point well taken, it is not the institution that does that work. Secondly, with regard to, are there ever disagreements between the president and the White House staff or whoever, right, on people who ought to be nominated? Yes, and there's also often debate. So sometimes the president will start off from a position where he doesn't particularly like, or thinks he doesn't particularly like a prospective nominee for some reason or another. And then there will be this back and forth over time where either the president will become a little more comfortable with the person or he won't. But that has happened. And now, any good judicial selection process knows enough about what a president is looking for that hopefully by the time the book, and I'm not just talking about Supreme Court, courts of appeals, lower courts, by the time the book gets into his office, right, there's not going to be, 40% of them aren't going to be the subject of debate, right, because that is not a productive use of the president's time. But the way the process works is for Court of Appeals nominees, oftentimes as few as 3 and as many as 13 to 15 are interviewed for any particular Court of Appeals seat. So it's a pretty rigorous process. And so when you narrow it down, by the White House. By the White House, no, not by the president. No president of the United States interviews Court of Appeals judges, not from either party. It's not been the practice. But they do get, the Staff Secretary of the President does present a book with their records and a memo, and that's how they make, and then there's usually a meeting with the White House counsel, and that's how decisions get made. So yes, there are times when the president will say, well, what is this person's background? Why are we doing him? And the answer might be, well, on this one, Senator so-and-so feels very strongly about this nominee. This is particularly at the district court level, okay? And the president may say, well, wait a minute here, can't we do better than this, okay? Or, this person's 63 years old, can't we find someone who's going to last a little bit longer on the bench? So you do get pushback from time to time, either because of, credentials or otherwise. Sometimes if it's a Supreme Court vetting process, that's a much more fluid process. So what happens there is, and I can tell you with both processes, it was a real ping pong match on a couple of occasions with regard to a couple of particular nominees, where the president kept on shooting questions back at the team, saying, well, wait a minute, what, does this matter? Does that matter? Does this person have the right disposition? So there is that fluidity. It's not a rubber stamp type process. And then your third question was about the ABA. I'm of a mixed view on the ABA's standards. I mean, I think on the appellate level, okay, I sometimes feel they put a little bit too much weight on pure litigation experience. I think they generally expect 10 years or more. And there are, because of the nature of appellate work, I'm not sure that that's really the right balance. And that's where usually arguments occur. And it happens quite often with academics, right? I mean, that's where we get the most pushback from ABA committees. It's academics who haven't had any prior litigation or law firm experience. And sometimes it might be a legitimate concern if you look at the particular areas that professor worked with. Sometimes it might not be. So that's where...
I wonder if in emphasizing the potential harm to law professors, you're trying to appeal to the person who asked the question.
That's a possibility. So I didn't take trial advocacy, but I'll take it.
And I'm going to push you along so we get more questions.
Yeah.
There was also the question about
does he have a philosophy
core beliefs and the history of a contradiction on abortion issues.
Yeah. So yeah, on abortion. Yeah. Well, that's the one that's most prominent in terms of the public understanding of this, right? So that's a good example. I think at the end of the day, yes, the president has a philosophy or understanding of what he wants. Now, that became most apparent to me really about a week after the election. Because about a week after the election, there was a very long meeting at the Trump Tower, about an hour and 15 minutes long, where the task was to take the list and to winnow it down to 8, okay? So that was when there was a really serious conversation about what are you looking for? And in fact, that was my first question in that meeting. What is it that you were looking for? And we did talk about, obviously he's a non-lawyer and he's a businessman, but at a very general level, this Scalia idea of originalism. Again, not throwing that term around, but interpreting the Constitution the way it's written. And then the other time I saw this was after he was president, and started seeing some of the nationwide injunctions and other litigation that was taking place. And he asked some questions about the power of lower court judges to impose certain kinds of injunctions and how that works and how that fits with the role of the court. So, number one, I think he does have a very sort of firm but general understanding of what a view of the role of the courts, right? That really sets the tone for the process. And then secondly, and I think even more importantly, he does ask the right questions about the business of judging, the enterprise of judging. And I think he learns from that experience over time. So That's my own sort of take on it. I can't know for sure, but I do think so.
Great. Here's one back here. Over here.
Oh, over here.
Don't worry, we'll do two at a time. Here's one.
On February the 13th, 2016 is when Antonin Scalia died.
Oh, yeah.
There was a good 11% of Obama's term left. My first question is, was that not an Obama appointment to be made and not held over the way it was? The second thing is, yesterday I heard Ruth Bader Ginsburg said that the seminal change was the retirement of Justice Kennedy. He was 82 years old, and there was some word that he was pressured into retirement so that there was a second opening on the court. If you could comment on that. And the third is just the fact that we now have two new justices who are respectively 51 years and 54 years old, who are going to have a mark on the court for more than probably my lifetime. Could you comment on that, please?
And I'm going to do,
track of this.
yeah, well, I'm writing them down. I'm also going to do a little moderator's privilege, which is I'm going to pick, if you give me three, I'm going to pick one of them. If you give me one, then you pick one. Only because we promised, and I just, well, to be fair, I offered question or comment, that's sort of singular, but also to your question, I was inspired by Senator McConnell to just make up the rules as I go. But because I want to make sure we're getting everyone in the back here too.
Well, there's only two questions left because you answered the first one, right, Ari?
She had my question, although I did have something for Ari, though. Out of respect for your show, I'll keep loose, keep steady, stay on the right side of life, be strong, be ready to defend myself and say why when it matters. I'll keep it simple. I won't complicate what I know. I'll be myself, not a pretender. Then I won't have to put on a show. Goes to integrity, which went to her question about.
And who is that by?
That's by Macklemore, Benjamin Hammond Haggerty.
Macklemore, a great rapper, and I went to his high school in Seattle. I don't know if you know that.
So anyway, so that was the precursor to her question about the holdover for.
Great. So we have those questions. We have some Macklemore bars, and sir, why don't we do one more right here?
Actually, I'm kind of following on hers in a slightly different take, which is to ask you, given the McConnell standard, which seems to be that we only move nominations forward if the Senate majority is the same as the White House. My question is, does that provide you conservative comfort, or are you, to what extent, unsettled that the sustainability of that standard may not work out so well in the future, and therefore, for the benefit of the country, do you see it as a poor standard for nominations? So this plays off of the question about 11 months.
Okay. And also, what's your favorite Macklemore album? Put you on the spot. So why don't we try it with a lightning round and say, very briefly, yes or no, is there any truth to the idea that Justice Kennedy was pressured to retire? The notion of the age.
Can I just say on that?
Please.
I think it's incredibly offensive to Justice Kennedy, for those of you who know him, to suggest that that would be the way he was motivated. He is a man through his entire career did what he thought was right. And believe you me, I disagree with some of what he's done. Okay, but he was a man of, on the court and off the court, a man of tremendous integrity, honesty, and courage.
And had you heard that rumor?
He would not, I have never heard that rumor, that he was swayed. And no one in Washington who knows him would ever believe that that is even remotely possible.
The other question on the age, you know, this is relevant, but are justices being picked younger and younger for just for that raw tenure position? Is there anything wrong with that?
Absolutely. And I think it's a great thing. You'd be a fool not to do it.
And then the figure has put 11%.
Well, as long as you're qualified.
Right. 11% left of Obama's time, or as the gentleman over here was explaining, if there's concerns that the confirmation process itself has been overly politicized in its content, do you also share the concern that if the Senate is going to play this sort of what Jack Balkin has called constitutional hardball, you could technically do it, but boy, is it going to break down even filling positions on the court politically. Does that concern you at all, or do you just say, well, this is how it is now?
There was no question that if the shoe were on the other foot, and Senator Schumer made it very clear, as did Senator Biden some years ago, that they would do the same thing that Senator McConnell did. And so what basically, and if you look, all you have to do, look back at the judicial confirmation process going all the way back to 84, okay? You go all the way back to 1984, look at every major inflection point where the confirmation process substantively and politically changed, and over 80% of the instances where the rules of the game have been changed, either informally or formally, in my view for the worse, they have been at the hands of the Democratic Party. Now you can look at the history and you can make your own decision about that. But what you are doing is asking the leader of the Republican Party to unilaterally disarm, where over a period of over 25 years, Democrats consistently made very tactical decisions about hardball tactics they wanted to engage in the confirmation process. It's going to take a lot of will on both sides to change that, and the Merrick Garland confirmation process was not going to be where it happened. If you want to see changes to this process, you're going to have to do it outside the context of a particular confirmation proceeding. You're going to have to do it when there's no vacancy. You're going to have to do it when you're not within 1 or 1.5 years of a presidential election cycle. In other words, you're not going to see it happen.
I think some people might disagree with you on the history, but political history is charged for that reason. What are you suggesting, though, is the potential solution, given your proximity to how these things work, is that the Senate rules might someday be negotiated in a way where there was some actionable way to force when you have a vote or when you don't, and that somehow clears this up?
The problem is that it's never actually going to be a matter of Senate rules, because Senate rules at this point can change with the majority vote one way or the other. It's going to have to be a cultural change inside the Senate and inside the White House. Now, there was a time when...
Well, America's very good at dealing with cultural change right now. I mean,
well,
it's going really well. So you're saying that there's some sort of political détente at some point?
Well, there was a time when there were a majority of senators in the chamber who were serving in the Senate for more than 2 terms, many of whom had very serious concerns about some of the kinds of moves we've seen lately. Many of those senators have now either retired or died, and you have a new group of people in there who are only accustomed to, thrust and parry warfare. That's what they know.
So your view, basically, I mean, is this is probably only going to get more intense for now?
Yeah, I think it has the potential to get more intense, and it is possible, as it gets more intense, some people in the Senate might show some leadership. You have some Democrats and some Republicans in the Senate who could potentially look back on this, maybe one more Supreme Court confirmation, and say, you know what, we just can't do this anymore.
I think we can do one final round of questions, and then we'll stick to time and wrap up. Are there any final questions or comments on any topic? There's one in the middle here, sir. Oh, right here, sure.
Very interestingly, you began by stating your motivation for getting into the sort of work you do as a concern for the constitutions, and specifically the protection of the separation of powers and the balance of powers. I wonder how you feel about the current situation as between the executive and legislative branches.
Well, interbranch relations question. Anyone else?
Okay.
Before we go, this is the last in the middle. This sir here. Yeah, they'll bring you one. We got a mic coming. Bear with us. And then we'll do one more in front. If we have one more mic in front, we can round it out.
It's been suggested that with the current composition of the court, that the Chief Justice might serve more nearly a centrist function. To what extent, if at all, do you believe that that might be the case?
Okay.
And we'll do, this is the last question in front.
What happens if the Senate does not exercise its right to consent?
So a question about the Chief Justice, interbranch relations in general, and this sort of as a subsidiary to that, if the Senate doesn't exercise its advice and consent function, can you have one or more vacancies indefinitely?
Sure. First, on the separation of powers issue, I mean, separation of powers, as one scholar once put it, is just an invitation to struggle, right? It always has been, it always will be. So I don't have a problem with situations where presidents and Congresses spar, even fairly hostily, over what their prerogatives are. In this case, for example, the extent to which legislative oversight extends to various prerogatives to see various, documents and so forth. I don't have a problem with that. Usually those things get sorted out through negotiation. Sometimes they have to go through the courts, and then ultimately, the court renders its decision about what the proper balance of power is. Where I would be concerned is if a court rendered a decision about what that balance of power was. Well, one, I'd be concerned if we entered into a political realm where we could never negotiate these things again. So I would really be concerned if we can't work these things out without court battles. And then secondly, if there were a court battle, I'd be very, very concerned about a republic if we ended up having a president or Congress who ultimately refused to respect the court's judgment about what that balance of power was. As for the second question, which was
Chief Justice.
Chief Justice and the centrist role, and okay, I mean, I personally don't view that as the role of a Chief Justice. I think the Chief Justice's role is one, he's got the same voting power on the court that every other justice does, and I don't think that the role of a Chief Justice is to have a unique role in defending the reputation and credibility of the court. The best way for every justice of the court to do that is to do what they think is right when they render decisions, and not try to play politics. It's when any member of the court decides that they're going to be a great political strategist and figure out how to navigate the political world in making decisions when the court's reputation begins to become tarnished or tethered. So I don't think that's the role of a Chief Justice. I think the role of the Chief Justice is to maintain collegiality among the justices, have a good functioning court, hire the groundskeeper, and basically, make sure everybody's doing their work.
What's the ability of playing that role? Not the question of what is the role of.
Well, I mean, this Chief Justice has said publicly in a speech that he gives about Chief Justices that he does think that the Chief Justice has a unique role, I think, to play in helping to maintain the reputation and credibility of the court. I don't know that he would go so far as to say that he would render decisions with that in mind. I don't think he would agree that that's what he's doing, okay? So I think one has to be careful about how far one goes with that argument. I don't think that Roberts would say, well, I decided this case this way because I'm the Chief Justice and I thought it would be bad for the court's reputation. I don't think he would agree that that's what he's doing, although some people accuse him of that. And then the final question was advice and consent. Well, there's no constitutional requirement that the Senate exercise its advice and consent power. Just as there's no constitutional requirement that Congress make a law. Am I troubled by when they fail to exercise their advice and consent power? No, not particularly. I think the political process will sort it out. If people think that it's incredibly negligent for the Senate not to be acting in some way or another, I think the political process can respond accordingly by voting them out and picking different leadership. So I'm not personally troubled by it.
I'll close with an observation from my adopted line of work, because I started as a lawyer and now I do some journalism, which is often the people with the most power and influence are the least available, for the obvious reason that there's not a lot in it for them to explain their access or what they do. They get to do it. And so it is always, I think, enlightening and interesting to hear directly from people who are in the room, who do make these decisions, who are dealing with matters of state, and particularly when they're willing to do so candidly and bluntly, which I think you have more than met that standard today. As a proud Cornell alum, I want to thank you, Leonard Leo, for joining us and being part of these reunion festivities, and thanks to everyone for coming. Great job.